Good afternoon, everybody. So today we're going to review a case concerned to the United States District Court, Southern District of New York, between the Andy Warhol Foundation versus Lynn Goldsmith. So we can call the Warhol versus Goldsmith. This case raises the question of whether Andy Warhol used our photograph of an iconic singer as a basis for the series of artwork it protected at fair use. And this case move into many levels. That's the first level. And then we go to the Court of Appeal and then the Supreme Court. So that really a landmark case, very important for the students to understand everything about the copyright and about the fair use. More particularly, the Andy Warhol Foundation for the Visual Art issued a declaratory judgment declaring that work created by Andy Warhol based on a photograph of French Rosy Nation, best known as French, taken by photographer Lynn Goldsmith, do not constitute violation of the Copyright Act. Goldsmith had feared a counterclaim against AF, claiming that Warhol work do constitute copyright infringement. AWF moved for summary judgment granting its request for a declaratory judgment and dismissing Goldsmith's counterclaim. Goldsmith moved for summary judgment denying request for declaration judgment and holding that AF infringed her copyright. For reasons discussed below, AF motion is granted and Goldsmith motion is denied. The standard for granting summary judgment is well established. The court shall grant summary judgment if the movement so that there is no genuine dispute as to any material fact, and the movement is entitled to judgment as the matter of law. The trial court task at the summary judgment motion stage of litigation is carefully limited to discerning whether there are any genuine issue of material fact to be tried, not to deciding them. Its duty, in short, is confined at this point to issue fighting. This does not extend the issue resolution. The moving party bear the initial burden of informing the district court of the basis for each motion and identifying the matter that is believed demonstrates the absence of genuine issue of material fact. The substantive law governing the case will identify those facts that are material and only dispute over fact that might affect the outcome of suit under governing law will properly preclude the entry of summary judgment in Anderson versus Liability Lobby, INC, 1986. In determining whether summary judgment is appropriate, the court must resolve all ambiguity and draw all reasonable interference against the moving party. See Matsushita Electronic Industry versus Zenith Radio Corp, 1986. Summary judgment is improper if there is any evidence in the record from any source of which a reasonable interference could be drawn in favor of the moving party. If the moving party meets its burden, the non-moving party must produce evidence in the record, might not rely simply on conclusion, the statement, or on contention that the affidavit support the motion are not credible. So then the court they cite many information, and that's basically this is the paper, the Purple Fam article accompanied by Warhol illustration in print. And this one is the 16 print series work, they just imitate and change the color of the face into different work. And unfortunately, the prince died on April 21, 2016, in Goldsmith. The next day, Vanity Fair published an online copy of its November 1984 Purple Femme article, which had credited Warhol and Goldsmith for the print illustration in the article. Condé Nast then decided to issue a commemorative magazine titled The Genuine of Fringe and obtained a commercial license to use one of Warhol print series work as the magazine cover. The magazine contained a copyright credit to Warhol, but not to Goldsmith. Condé Nast published the magazine in May 2016. Goldsmith first learned that Warhol created fringe illustration for Vanity Fair after Fringe's death. Before then, she had never seen any work in the print series. Goldsmith contacts AF and advised that she believed the Condé Nast magazine cover infringed one of her print photograph copyright. Initially, she told AF what Condé Nast used infringed one of her color print portrait, but after further comparison, notified AF that Condé Nast used actually infringed one of her black and white portrait, the Goldsmith print photograph. Following this exchange, Goldsmith obtained a copyright registration for the Goldsmith print photograph as an unpublished work. The Condé Nast magazine cover and Goldsmith print photograph. AF has made each of print series work available for licensing to third party to use in the book, magazine, newspaper, and for other merchandise purpose. Goldsmith licensed single image to her photography for various editorial and commercial uses, often to magazine and record company. She also offers mosaic print, which is composed by combining several of her image and fine art print. But Goldsmith had not yet edition or show any print of her Goldsmith print photograph. Goldsmith testified that she had not done so because she doesn't edition all her work at once. And as she gets older, she intends to start editing her other work, anticipating that price will then go up. Goldsmith testified that in 24, she sold a fine art print of print that she created in 1993 to a private collector who also owned 3 Warhol work at work. Moreover, between 2005 and 2016, Goldsmith issued 10 of 11 licenses for all the Goldsmith photograph of prints, photograph not taken at the December 3, 1991 studio shoot, but in other venues such as concert, Tourette magazine, and venue. However, aside from the license to Vanity Fair in 1984, Goldsmith does not recall licensing the Goldsmith Fringe photograph or any other photograph that she took at December 1981 studio shoot. AF seek a declaratory judgment declaring that none of the 16 work in the Fringe series infringe the copyright of the Goldsmith Fringe photograph. AF argued that Fringe series work are not substantially similar to the Goldsmith Fringe photograph, and in any event, the Fringe series work are protected by the fair use doctrine. Goldsmith, on the other hand, seek summary judgment denying AF request for declaratory judgment, holding that the Fringe series work infringe the copyright of the Goldsmith Fringe photograph. She contends that Warhol copied a photograph in creating the print series. That the print series work in their final form and substantially similar to the photograph, and that IF does not have a variable fair use defense. IF also raises a status of limitation defense. I win that the Copyright Act 3-year status of limitation bar Goldsmith from claiming infringement for act that occurred more than 3 years before she brought her claim. Goldsmith countered that under the discovery rules, copyright infringement claims do not occur until actual or constructive discovery of the relevant infringement. Goldsmith added that either way, her infringement claim is based on AF licensing in the print series, work to Condé Nast in 2016, which is well within the limitation period. Goldsmith, similarly, any further licensing of the print series would allegedly constitute new act of infringement for which Goldsmith would have a remedy. IF does not dispute that this particular claim is timely brought. Photographs are generally considered creative work that merits copyright protection. Almost any photograph may claim necessary originality, support copyright. The protectable original element of photograph include posing the subject's lighting angle, selection of film or camera, evoking the desired expression, and almost all the variant involved Roger business con. But the aspect of photograph does necessarily follow from photograph idea or photographer choice of given concept are not protectable. Thus, although the element constituting photographer original expression of a subject are copyrightable, the subject itself and general feature that subject are not. To establish copyright infringement, two elements must be proven. First, ownership of valid copyright. Second, copyright of constituent element of the work that are original. A party can pursue a copyright infringement claim in court once the copyright claimant has properly filled in a registration application and the copyright register has examined the application and registered the copyright. The party here do not dispute that Goldsmith had a valid and registered copyright for Goldsmith print photograph. The second element of copyright claim has to support. Goldsmith must demonstrate first AF copy a work and then that such copy was unlawful because of substantial similarity exists between the allegedly infringing work and the protective element of the copyright work. To establish the first part of the absence of proof of direct copying, a party may establish copying circumstantially by demonstrating that the person who composed the work had access to copyrighted material and that there are similarities between the two works that are probative of copying. The similarity established in this stage to prove copying is referred to as probative similarity. AF does not deny for purposes of those motions that there were access and sufficient probative similarity to establish a Warhol copy, the Goldsmith print photograph, at least to some extent. Once actually copying has been established, the copyright owner must then satisfy the improper appropriation requirement by demonstrating that substantial similarity and to the protected element of the work would cause an average lay observer to recognize the alleged copy as having been appropriated from the copyrighted work. This ordinary observer test asks whether the original observer, unless he set out to detect the disparity between the two works, would be disposed to overlook them and regard their aesthetic appeal as the same. When the protected work contains both protectable and unprotectable elements, such as a photograph, court must take on a more discerning comparison to extracting the unprotectable element from consideration and then considering whether the remaining protectable element of the work are substantially similar. However, this comparison must not be so discerning that the protected work, total concept and feel is ignored. See Boson versus Banyan Ltd. Goldsmith alert as one theory of infringement that Warhol or his agent reproduced her entire photographic, including its protectable and unprotectable element, without authorization at some point during Warhol process and creating the print series. Although this is a valid basis for an infringement claim, it's related to conduct that occurred nearly 40 years ago as well outside the Copyright Act status of limitation. Goldsmith appeared to recognize this and focuses her infringement claim primarily on AF more recent licensing of the Fry series work named 2016 license to Condé Nast and claimed by AF that she had the right to continue license and the print series work. And then AF argued that this not infringe copyright of Goldsmith to her print photograph because none of Warhol print series work, including the work licensed to Condé Nast in 2016, are substantially similar to the Goldsmith print photograph under the ordinary observer test for substantially similarity. But the court need not address this argument because it explained that the print series work are protectable and fair use. Fair use is a statutory exception to copyright infringement, and this part they explain about the fair use factors. First, second, third. So they have the 4 factors of fair use here. And then they show out some case law of Kenneth. The very interesting of common law is they use many case law in order to prove the problems. So the first, third, and fourth fair use factors favor AF, and the second factor is neutral. A holistic weight of the factor point decidedly in favor of AF. Therefore, the print series work are protected by the fair use and Goldsmith copyright infringement claim is dismissed. Conclusion. The court has considered all the argument raised by the party. To the extent not specifically addressed, the arguments are either moot or without merit. For the reason explained above, AF motion for summary judgment is granted, and Goldsmith motion for summary judgment is denied. Goldsmith copyright infringement counterclaim is dismissed. AF should submit a proposed judgment by July 8, 2019. Goldsmith may submit any objection of the counter judgment by July 10, 2019. Plus, it direct to close or pending motion. So that's the case of United States District Court on the fair use Warhol. Very, very interesting. And then we go into see Court of Appeal and the Supreme Court. So if you have any other question about the case, please let me know and I will make more comment on the case law. Thank you.